Good morning, all. This hearing is in the matter of CFI 069-2024 and is being held by way of video conference before His Excellency Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are litigants in person, represented by Mr. Sham Uddin. The defendant is represented by Hadif and Partners. Lead counsel is Mr. Guy Blackwood, KC. Thank you, Your Honor.
Yes. All right. Well, where are we going to start today? Have you agreed anything between you?
We haven't, Your Honour. I was going to propose that since we have two applications before the court, it would be for me to go first. Those are, as Your Honour will have seen, the unless order application and the security for costs application. So I was going to take, unless there's any objection, the unless order first, followed by the security for costs order.
And then we move to case management.
Yes, then directions, because the directions will, to some extent, for obvious reasons, Your Honour, depend on the outcome of those applications.
Yes, all right.
So I was going to start. Your Honour will remember making an order in March,
Yes.
which required the provision of further information and copy documents. I don't know if I need to refer Your Honour to it again. It's at page, and I apologise if tab numbers and page numbers are not always exact, Your Honour. The bundle has been something of a moving target as regards both because of the electronic means by which it's compiled. But Your Honour should have the order at page 494. That is bundle B. It will either be tab 10 or 2. At page 494 to 504 is Your Honour's order of March, 19th of March of this year. Unfortunately, given the size of the PDF document generated, it's not possible, or not easily possible, to do this quickly electronically.
No, I have that, thank you.
Thank you. So Your Honour will see paragraph 2 on the second page. That the claimants were to provide within 21 days the further information and copy documents set out below. Paragraph 17 of that order is relevant. That's page 501, I think, for the unless order application. Producing documents showing the terms, this is of the banking facilities, from the Bank of India, Baroda and Mashreq Bank, and demands for any repayments.
You can take it, Mr. Blackwood, that I'm reasonably familiar. I've read this again and looked at the materials that I was asked to read. When it comes to absolute matters of real detail, you may need to address me, but I'm familiar with the substance of it.
I'm very grateful, Your Honour. In which case, Your Honour, I'd like to move straight on to the claimant's written response to the application. It comes in two tranches. We firstly have a written submission signed off by a statement of truth and then a witness statement. So I'd like to start, please, with the written submission. That is in tab D, 22 or 6, page 1709. Just to run through briefly what was said and to make submissions on this submission signed by Mr. Garg with a statement of truth on 30th of July. So paragraph 3 on internal page 2. On 23rd of December 2023, the bank, this is the Bank of India, formally requested our Singapore team to provide verification and proof of authenticity of the trade documents. So there's a suggestion here of a formal request, but no document has been provided. Then, following its internal review, this is the bank, The bank confirmed that several bills of lading submitted by the defendants were forged, raising serious concerns of fraud, forgery, and violation of AML regulations. In consequence, the bank immediately froze the Keshav's global account and issued again a formal warning, indicating that the matter may be referred to regulatory and enforcement authorities. Then the matter was escalated further. Subsequent high-level discussions, including a meeting the bank's head office India, resulted in Keshav providing, quote, comprehensive clarifications and documentary evidence that it had been misled by the defendants, an entity with an international established presence in the agri-commodity sector. Again, none of this has been produced, none of the documentary evidence or comprehensive clarifications. We then have a suggestion at the bottom of this page that on the 5th of February 2024, the Bank of Baroda, obviously a separate entity, having been alerted to the fraudulent shipping documents by the Bank of India, summoned Mr. Garg and, quote, formally instructed that all outstanding facilities be immediately settled. That's obviously a very surprising statement because it would involve a serious breach of confidence by the Bank of India. Then on the following page, a subsequent meeting on the 7th of February concluded with a firm ultimatum. The bank would be compelled to initiate legal proceedings, including criminal, for forgery, fraud, and anti-money laundering violations. The bank advised that any continued exposure would pose significant regulatory risk for both the bank and the borrower. Then the following paragraph, to avoid the matter being formally documented in a way that could prompt regulatory escalation or damage Keshav's global reputation across the financial sector, we expressly requested, again, no documents provided, the bank to refrain from issuing any written allegations. This request was acknowledged, no document to back that up, and the bank agreed to cooperate on the strict condition that all facilities be closed without exception or delay. Although Keshav promptly provided all relevant correspondence and evidence to establish the following paragraph that it was allegedly deceived by the defendant's fraudulent conduct, nonetheless, the bank insisted on the immediate and unconditional closure of the facilities. Just going on before we get to the summary, Keshav Global voluntarily and in full repaid the separate loan from Mashrek Bank. The loan document has not been produced, so it's very unclear how the claimant could establish that this was a voluntary repayment or in any way connected with the matters alleged.
Well, that raises a basic point that you're going to have to deal with at some point, Mr. Blackwood, which is I know what you say about the inadequacy of all that's been done. But in the overall scheme of things, how does any of this prejudice you in terms of dealing with the case at this stage? Obviously, disclosure is yet to come. And I can tell you now that what I'm thinking of in terms of disclosure is standard disclosure in English terms, which means that both sides will have to produce documents that both support their case and undermine it or advance the case of the opponent. In which case, where are we really going with these particulars? Because you know what the case is. You say it's incomprehensible, untenable, unsupported by evidence, and so on and so forth. But so what?
But Your Honour, there's been an order back in March that and we say that this is not credible, and the only proper
I understand. Mr. Blackwood, don't get me wrong. Yes. I understand exactly what you say about credibility. Yes. But as matters stand, Mr. Garg is saying, I've given you all I've got. Now, you may not believe that. I understand that. You may not believe that. And you may want to cross-examine him on it. And you may want to say at some point that none of this takes you anywhere near establishing any of the losses that you claim. Well, so be it. But it does seem to me at present this is rather disproportionate, if I can put it that way.
But Your Honour, the inference we say that really can be reasonably drawn is that there's been flagrant breach of your lordship's order of March. And it's really Groundhog Day. We're back in the same position because this explanation is incredible. And if it is incredible, as it is on its face, I'll come to Mr. Guard's witness statement in a moment. The reasonable inference is that there has been a flagrant contumacious breach of Your Honour's order. This was a long time ago. This has led to enormous costs. On huge amount of correspondence, and we're no further forward. It is not credible that banks such as Bank of India and Bank of Baroda, first-class banks, suppressed fraudulent documents which they themselves, Bank of India, are supposed to have discovered. That Bank of India then spoke to Bank of Baroda in breach of confidence, raising the same issues, that none of this was documented. And the reasonable inference is that Mr. Garg has not disclosed this correspondence, some of which must exist, because it doesn't support his case, and therefore he prefers to breach Your Honour's order, which was in clear terms. I mean, Your Honour will have seen some of the loan documentation. I don't think we need particularly to turn that up now, but it is noteworthy that it expressly makes as a condition of the loan compliance with KYC and AML regulations. That's in the Bank of India loan documentation. And the notion, therefore, that a bank that takes these matters so seriously, such as to expressly include them as a term of its loan documentation, would then, having discovered itself fraudulent documentation, acquiesce in a request to keep nothing in writing whilst passing on the documentation to another bank, is incredible. And if that's right, the inference must be that your order's been breached, that this documentation is intentionally being withheld. Because, I mean, one talks of formal requests, formal demands, production of comprehensive clarification and documentary evidence to establish that apparently the defendant misled the claimant. That cannot be is not consistent with the notion that we've been given everything that exists. I mean, in the very words, formal warning, formal instruction, comprehensive clarification and documentary evidence. So that there has been, without question, a flagrant breach of Your Honour's order. We're not saying everything should come to a standstill now, but if Your Honour is persuaded by that submission, as we submit, one ought to be, because there's really no other respectable explanation, then the claimant has another 7 days to produce the documents that must exist. All these heads of loss are struck out.
Well, supposing I'm with you on your point about breach, why does it make sense to strike out those pleas?
It makes sense.
Wouldn't it be a more, well, let me make a suggestion, Mr. Blackwood, and see what you make of it. Would it not be a more proportionate response for the court to be saying, unless you produce documents, further documents, which are said by the respondents, the defendants, to exist, but you say don't exist, unless you produce those within a set period, you're debarred from producing any further documentation in relation to the claims that you make. Now that might lead you to want to make some further application thereafter in relation to the unsustainability of some of the losses. But as matters stand, the position I've got, Mr. Blackwood, is I'm being told by one side there are no documents. You say that's utterly incredible. and you have reasons for saying that. But for me to take that view at this stage, without Mr. Garg being cross-examined and so on the credibility of what he says, is quite a strong step. Much better, it would seem to me, if you're right on your point of flagrant breach, to set a time limit to produce documents, and we'd come to disclosure, obviously, in due course, and say that if you don't produce them by then, that's your lot. You can't produce them at a later stage without special permission from the court and good reason as to why they're now coming forward. What do you say to that as a general proposition, assuming that I'm with you for the moment about the likelihood of a breach?
Your Honour, that is obviously an available alternative, but it's not a satisfactory one from my client's perspective. When one looks at the heads of loss, they're paragraphs 43.2 and following. This is page 31 of the bundle.
You can take it. I printed off some of this stuff, so it's because
I'm very grateful.
I find it always takes forever trying to pick them out on the.
It's good to know I'm not the only one.
Well, it just you watch this. You watch this blue circle going round and round forever and a day, and I rather prefer to look at it the night before and print off from the case events bit or from the separate PDFs. As a matter of fact, I can't even find the document you were just referring to with Mr. Garg's reply, not his witness statement. But just to be quite clear about that, where were you telling me to look in bundle D? I only have 10 items in bundle D.
Yes, Your Honour. Unfortunately, the tabs and the pages have both been moving feasts.
Yes.
The bundle D, it is tab 6. It are the written submissions. And then tab 9 is the witness statement, which is largely duplicative. I haven't taken Your Honour to that, but again, references to formal warnings, etc.
It's almost evidence. It's almost word for word the same, isn't it?
It is. I don't think there are any material. Yes, almost word for word, firm ultimatums, etc.
All right. Anyway, sorry, we're going to go back to the particulars of claim you wanted me to look at.
Yes, please, Your Honour. Just briefly, it should be page 31 in your bundle, which is because this is
again.
Yes,
I've got hard copy again.
Thank you. The real problem with allowing this to proceed, even under a debarring order, as to evidence, is that enormous costs are now going to be incurred addressing these heads of claim. That is because they are said to require expert evidence. For example, 43.3 expert evidence, 43.7 expert evidence, etc., and 43.8 expert evidence. So we're now at a juncture where, from a costs perspective, it really does make sense either for these claims to be properly advanced with disclosure that must exist, so that the experts can actually look at that and form a view properly based on evidence, or for the claims to come to an end. Your Honour will have noticed, of course, as expressly pleaded, all of the heads of loss in 43.3 through to 43.8 are expressly parasitic on the early repayment as a result of the repayment. So if these early repayments, by apparently the require to close these facilities, if that head of loss falls, then the remainder do, and all one would be left with is a claim for about $210,000, 43.1. These are the losses arising or said to arise from the particular trading transactions. Ironically,
I couldn't make the maths work on those two figures, but there it is. when I looked at the individual trades and the profits and losses on them. They didn't seem to add up to those figures.
No, Your Honour, and that's one of the points I was going to make when it comes to directions, which is that there appears to have been intimations that there will have to be an amendment to correct figures, and indeed a suggestion of further parties to the litigation. So, all of these.
I was going to interrupt again, Mr. I know I keep interrupting, Mr. Blackwood, but it may be helpful because it will help you to address the points that I'm concerned about. On the face of the pleading, if you are able to establish that the reason for repayment of the banks had nothing to do with these shenanigans at all, but was either because the claimant had terrible financial difficulty in any event and they called in the loans for other reasons, then all of this disappears. I understand that entirely. So don't get me wrong, I understand the importance of the point. But it's still, when I'm being told that, that there is no more to disclose, and we have yet to come to disclosure in any event about the banks calling in the loans, at some point I'm going to have to decide whether or not that's credible, and that's hard to do without Mr. Garg being given the opportunity to have his evidence tested on the subject. Maybe it's a preliminary point. I don't know.
I understand. I mean, maybe that would be another way to move forward, but we do submit, Your Honour, that the evidence is so incredible here, where one has, in Mr. Garg's own words, reference to formal demands, ultimatums, provision of documentary evidence, that there must be something. There's been a breach that's been alive for a considerable period of time. And we are now at a juncture where a lot of money is going to have to be spent. Of course, one could address the financial position in one of two ways. One could, if a strikeout is not to be contemplated in connection with the unless order, another way of protecting the defendant would be to make a security for costs order, and to attach the same relief to that if that's not met. Because really, as a matter of fairness, the defendant ought to be fully indemnified if it is based on the evidence of Mr. Garg, to be put to the expense of meeting all of these heads of loss claims.
Something to be said for looking for an economic solution to this. If you have, as you say, you have a knockout point as to whether there's some way of reaching that without depriving Mr. Garg of the opportunity of making good his points about what the banks do. I'm afraid I don't find everything that you say about the bank's likely responses to be, I mean, I can't say I find it totally incredible. My experience of banks in litigation is that they often don't do what they're meant to do and observe the regulatory requirements. And this business of Singapore circular trades is quite a fashionable thing, as you probably know.
Yes, I mean, and there's nothing inherently wrong with
as long as they're real.
Circular trade.
As long as they're real, yes.
Well, absolutely, but
yes.
But one also has the tension here, Your Honour. Yeah, you've got very formal and ordinary banking documentation. You've got an express statement by Mr. Garg saying that the bank uncovered this fraud. You've then got apparently the Bank of India telling the Bank of Baroda about it, which is extraordinary of itself, and then both banks trying to suppress everything. You've also got formal.
You haven't required Mr. Garg to come and be cross-examined on his witness statements, have you?
No, that's it.
I'm looking for some way in which to deal with this that is sensible and economic. If you're right, and this case is entirely manufactured and contrived, then I'm entirely with you that one should try and get rid of it at the earliest possible opportunity, but without unfairness to Mr. Garg, who is sometimes represented and sometimes not. And I'm very pleased that Mr. Udin is here today to speak on his behalf. But he doesn't have the same resources available to, as you have. But at some point, I'm going to have to decide on his credibility, aren't I? And you're really asking me to find on his credibility now, without having that evidence tested in cross-examination. On the face of what he says, there's a bit of a problem.
Well, I am asking Your Honour to do that by reason of the evidence that's been put forward. Right. But if Your Honour, as Your Honour has indicated, isn't prepared to do that, then the appropriate way forward would be as you suggested, which is that somehow this is dealt with as a preliminary issue, and that the order be coupled with a full order for provision for security for costs, which I'll come to, which ought to be complied with, and a sanction attached to that. Because my clients are concerned about spending enormous amounts of money, which they may not recover.
I understand that entirely. I'm just exploring the possibilities, Mr. Blackwood, and forgive me for the interruptions, but if we were going to go down that route of looking for a preliminary point, so to speak, one would need to have an order that dealt with disclosure, and then, in short order, a disclosure that is referable to the particulars and specifically referable to this knockout point, essentially, in relation to paragraphs 43.2 to 43.8 and the dealings with the banks. So it would be a preliminary point that was addressed to whether or not the credit facilities were closed off by the banks as a result of discovery of a fraud in the circular trades. I know you say they're not necessarily circular because of connection to the PACP and so on, but making that assumption for the moment. And that preliminary point taking place with the opportunity for Mr. Garg to appear, having been given time limit to produce whatever documents he wants to rely on and whatever documents would undermine his case. It's not an easy thing to frame. I appreciate that, and you may not want to do that on the hoof, but the question is that a realistic way of doing this that's going to be economic? Taking security for costs for one side for the moment.
Yes. Yes, I think that might work, Your Honour. We would frame the question. Ideally, we would be given, as Your Honour indicated, a little bit of time to make sure it's framed correctly. We'd seek to agree that with Mr. Udin. And then a very short deadline for production of documents, as Your Honour indicated, in the English sense, disclosure. Followed by a short hearing on this point.
Yeah, so the disclosure would be specifically limited to the preliminary point at this stage in order to try to minimize costs, so to speak, in dealing with what you say is essentially a knockout point.
Yes, Your Honour. I don't. Obviously, I'm speaking without instructions on this. And I'd need to take those, and we would need to frame the preliminary issue. But I think from my client's perspective, this would have to be done insofar as is possible, as quickly and cheaply as could be done.
Yes, well, if I'm not with you on your primary submission, which currently I'm not enamored of because I think there's an element of unfairness in it. I think that might be the way to go. What I was wondering about was this, Mr. Blackwood, if I asked Mr. Uddin what his response is, and if this is a route that I think it's worth going down, if I then give the parties half an hour or so to take instructions, we've got quite a bit of time set aside today, haven't we, for this?
Yes, Your Honour. There is a huge amount of documentation, which I think led to the conservative time estimate, but not that much is actually relevant.
Right. So my point is this, that if, subject to what Mr. Uddin says, this is a route that is available and sensible, it might make sense then to take some time out for the parties to take instruction and for you to stop and frame the question so that we can actually get an order sorted out today.
Absolutely, Your Honour. We would certainly be in favour of that approach.
Do you want to say anything more at this stage? We'll leave aside security for costs for the moment. Obviously, if I make an order of that kind, the security for costs would then, if it's to be ordered, tailored to that particular procedure.
Yes, it would be.
But do you want to say anything more before I ask Mr. Uddin what he wants to say?
Not at the moment, no, Your Honour.
Thank you very much. Mr. Uddin, you've heard what I've said. I'm not sure really to what extent, you know, how involved you've been in this matter and therefore how much up to speed you are, so to speak, on all the developments. You've obviously been able to look at the documents and get a flavour. But what is the current position as to your instruction?
In regards to the unless application, Your Honour, if I could just, I hear Your Honour's preliminary review, if I could put it in those terms,
Yeah.
as to if you're not with my learned friend in regards to the application, but may I deal with the substance of that application, and then Your Honour could then obviously either refine the position or change the position. But I wanted to just deal with the application head on, if I may, because in essence, the defendant's application is there's been a non-compliance with Your Honour's order. I disagree with that, and if I could just deal with that, and then just like you've stopped my learned friend in his tracks, you may do the same thing to me and say, well, Mr. Uddin, I hear you, but not with you on this or not with you on that. Can I just develop my argument in that regard with your leave?
You can, but if you do, Mr. Blackwood will have a right of reply, and as I've cut him short on all the things he wants to say, it might be quite a long reply.
But I'm hoping, Your Honour, I'm not going to giving I'm hoping I will keep my submissions very brief if I can, bearing in mind what I've heard. But I am obviously can I try and attempt that and then take it?
Yes.
Your Honour, in regards to the way my learned friend has referred to the bundle, the way I'm going to refer to the bundle as to the pagination. In fact, the pagination works. They're concurrent with the electronic pagination as well as the page numbers. And if you've got the same system as I have, if you just type the page numbers and it will just take you to it automatically on the sidebar. So if I may, with your leave, and I appreciate you may have all this printed off already, the starting point for this application really is Your Honour's order of the 19th of March. Now, Your Honour's order and the particular aspect of it, if I could take Your Honour to page 500 and paragraph 15, when this matter came before Your Honour, it was Your Honour who had made the order for the disclosure. And in paragraph 15 at page 500, Your Honour stated, despite the absence of any application by the defendant for further information and production as a matter of efficient case management and in order to avoid further delay, that's just then at paragraph 17, it is effectively Your Honour's order. And in that, in essence, Your Honour would have had the overriding objectives in mind. And
yes.
And I'm sorry, you know, it is important in this case to remind ourselves of overriding objectives, and it's it's to ensure that the parties are on equal footing, etc. But and on that basis, Your Honour, despite there being no application, and then paragraph 17A, Your Honour has clearly stated, I'm apologise that Your Honour may already have read this, but just to remind myself, what Your Honour was asking for is credit facilities, producing documents, but Your Honour did say there is no need for any particulars to be given of the attempts to obtain replacement credit, since this is a matter of evidence and would doubtless give rise to request for disclosure. If I just pause there for a moment, Your Honour, and then I refer Your Honour to page 515. And again, if Your Honour were to type in 515 on the sidebar, it will take you straight away to the document I'm referring to. That is the response that my clients made as part, and in that, Your Honour, they have comprehensively dealt with, to the best of their ability, to comply with Your Honour's request. But not only that, Your Honour, they provided the, at page 555, please, Your Honour, with your leave, is a index to documents that were supplied with the answers. Now, going back to, as an example, to my learned friend's skeleton argument in relation to the non-compliance, they say, for example, my learned friend at paragraph 30, I'm just giving an example, and I'll come back to the main point I'm making. At paragraph 30 of my learned friend's skeleton argument, page 7, internal page, for example, says, as regards Mashreq Bank, no facility letter has been produced. The claimants say it cannot locate. Well, let's pause it for a moment. In the page 555 of the index to the bundles that were sent as part of Your Honour's order, a Mashreq Bank offer letter was sent. Now, that letter makes it clear in my respectful submission that there was that facility. Now, thereafter, Your Honour, if we stick to that same index bundle, if we go to page 556, item number 13, letter from Mashreq Bank closing facility. The reason I pick out those examples, Your Honour, this is the claimants complying with Your Honour's order. And Your Honour's order was made in order to allow the defendants to see what case to meet. But by their application, what they're trying to do is to have disclosure, trial, everything at the same time, because as Your Honour has quite rightly said at the outset, well, hold on, we haven't had disclosure. Those weren't the exact words Your Honour said, but those are the sentiments that I understood. This is a case where that order of Your Honour's was made in order to facilitate and allow for the defendants to plead, in essence. Thereafter, Your Honour, they raise questions, and I submit this appears to be more of a fishing expedition, or this is a party, the defendant, which has quite amount of resources available to them, but asking the question, but what is the position in regards to those requests? Then I take Your Honour to page 1709, both on the pagination as well as the pagination written on the document, is the claimant's response to the unless order, where Mr. Garg gives the explanation as to, and Your Honour has already said, if Mr. Garg is saying, look, I have been given verbal, I don't have any documents, and if the defendants question the veracity of that testimony, when we go to trial, the court could make an inference and say, well, you haven't disclosed, how do you, because it's, of course, it's for the claimant to prove its case. It's the burden is on the claimant to prove its losses and its case. But at this early stage of a case, what the defendants, in my responsibility, am making this application, are trying to say, well, prove your case now. And that cannot be, in my expression, correct. And thereafter, Mr. Garg then there's another statement, Your Honour, dealing with that aspect of it. Page 1812. He deals with that and he gives the reason as to what has happened. Now, Your Honour, it is not implausible where the banks will say, look, just give us our money. We just want our money to be paid. And that's the end of the matter, because as Mr. Garg has said, the banks may have regulatory problems as well, or did have regulatory problem, and maybe they didn't want the paper trail. But the fact of the matter is, when it comes to trial, the trial court could say, well, hold on, how could this court give you any damages in the heads that you've pleaded because there's no documentary evidence? Or you may find Mr. Garg so credible that you make the order notwithstanding documentary evidence, because that's a matter for the court. So going back to this particular application, Your Honour, what was the purpose of Your Honour's order? The purpose was to the defendants to know what case for them to meet. Mr. Garg or the claimants have complied with that aspect of it by giving a substantial response, giving documents and saying, but they cannot produce documents they don't have. And like Your Honour said, well, if you, the defendants, don't accept what Mr. Garg is saying, cross-examine him, and the court could make a decision on that. But he has provided, or the claimants have provided, the documents that they have, notwithstanding the fact that we haven't reached the disclosure stage. However, going back to the English principles, every party to a litigation at the disclosure stage has to produce documents that prove their case or undermine their case. And we haven't got to that stage yet. And alternatively, they could ask for specific disclosure. And at that stage, the court could make a determination as to whether to make it in the form of an unless order or adverse inference order. Like Your Honour was stating earlier on, well, if you've got the opportunity to produce documents, if you cannot, then the court may make adverse inference. But those are the ways. So in my respectful submission, Your Honour, what more can the claimants do other than what they have already done? They haven't just sat back and non-compliant. And in fact, if one looks at the response, it's a substantial response to Your Honour's order. So for my learned friend to say the claimants have disregarded the disclosure order, that is not correct. The claimants have gone out of the way in order to produce documents, even at this early stage, to give documents. And in fact, the way Your Honour's order was made is akin to the English property court, where you give your disclosure at the start of your proceedings. They've had the advantage of a lot of the disclosure being given, which would have ordinarily been given at a disclosure stage. So in my submission, Your Honour, those are my submissions. I appreciate they're very brief. I'll go into details. But the statement given by Mr. Garg, he says, look, these are the documents I have no other. But one cannot just ignore some of the documents. There are facilities letters, but then there's repayments. And not only that, Your Honour, if I go back to, for example, one of the replies by Mr. Garg, for example, one of my issues raised by my learned friend about the interest, about the Liberia, these are all details. So, for example, if I could take Your Honour to page so yes, page 517. Your Honour will see how the claimants have detailed each of the facilities, and there you've got the matrix of paragraph 11 dealing with matrix facility, and then the demands for the payment. So they have dealt with it. And if this document, this answer doesn't give enough information to the defendants on how to meet, because the objective of your honours order was so that they know what case to meet. Now, causation is one thing, of course, quantum. Now, the fact is there is enough evidence that has been produced in order to show there is a case for causation, there is a case for quantum, but as to the nitty-gritty, those matters will come up in disclosure. And if at the disclosure stage, the claimant hasn't been able to produce the documents, or, for example, the defendants could say, well, we would like to, they're at liberty as well to contact the banks in regards to statements or disclosures or documents, and or make third-party disclosure applications. So I'm not sure, Your Honour, how much more the claimants could do, because they are also reliant on other people, and it's not beyond the realms of possibility that banks do not want to have the paper trails. So I'm not sure whether I've dealt with that point. If there's anything Your Honour wishes more to deal with, I can. But our main position is Mr. Garg's statements and the replies show that they have dealt with the order. It's Your Honour's order that the defendants are saying hasn't been complied with.
Yes. Do you want to say anything about the idea that we might have some preliminary point in relation to the closure of the bank facilities? I mean, as I read the particulars of claim, and you can address me on this, if one looks at paragraph 43.
Yes, Your Honour.
43. You've got in 43.1, you've got the small margin on the sales and purchases in trades 1 and 2, 3, 4, and 5. I say I can't quite make the maths work, but whatever it is, we're talking about a relatively small sum in the overall context of the case. But paragraphs 43.2 through to 43.8 all depend upon the closure of the credit facilities that then had an ongoing impact on existing contracts, future potential contracts, and generally lost profits, if I can put it in that way, and wasted investment. So is there a point to be taken that economically, dealing with the question of the credit facilities upon which Mr. Blackwood has focused would make a degree of sense?
Well, Your Honour, yes, if I could deal with that point, because obviously this is one element of the claim by the claimants. So if we're going to spend a lot of resources on one element of the claim, when the whole of the elements, all the elements of the claim can be dealt with at trial, what benefit or advantage is there to deal with that one aspect of it? I mean, preliminary hearing will take up the court's resources. It will mean expenditure. If Your Honour feels, well, I think to deal with the matter in that way will be proportionate, then so be it, because we have, from the claimant's point of view, we don't have anything to lose by going on that point, but other than expenses, because this matter could, in essence, be dealt with at the substantive trial. And if disclosure hasn't been given in advance to satisfy the court, then the claimants are at peril. But if Your Honour feels, well, it's a proportionate way of dealing with the matter, I'm not going to resist that. But the only thing I would say is this is just one element of the loss.
Well, yes, indeed. I mean, it's because Mr. Blackwood thinks it's a knockout point. You know, if he succeeds, then the rest of the claim fails, and the costs of dealing with that point would be less than going through the whole process. Obviously, if you win on the point, then one goes on to deal with all the other heads of loss, whatever they may be. But
I don't.
in a sense, it's probably more a matter for Mr. Blackwood than it is for you, because, as you say, your case is that following full disclosure, you can go ahead and prove your whole case.
You're not. That's why I say I don't push back on it very hard. But all I say is, if that's the way, because as far as we're concerned,
Yeah.
we are able to prove all of our heads of losses. However, if the defendants wish at this stage to have a preliminary trial, then so be it. What does it matter to us? But I'm in your honor's hands in that regard, if I could put it in those ways.
Yes. Can I ask you again the question I asked at the outset, which relates to your instructions? For example, when it comes to disclosure, who is going to carry out the disclosure? You don't have. I mean, we don't have solicitors appointed as such. As I understand it, you're appointed as his representative, but that's all.
Your Honor, I appear as direct access counsel
Right.
under the part two. So disclosure would have to be carried out by litigant in person. But obviously, the duties on a litigant in person is the same as any. But they will be carried out. But I will be assisting and advising in that regard. So they will be, well, if I'm still instructed, I will obviously I would give guidance into that, as well as witness them. So as Your Honor knows about direct access counsel, we do get involved in advising in stages in that regard, but my clients obviously are aware of the obligations, and they will fulfill that and take the advice.
Yeah, well, one of the great things about having lawyers and solicitors involved is that they know how disclosure works and they know what has to be disclosed, whereas an individual litigant in person often, whilst theoretically aware of the obligations, doesn't really appreciate the ramifications of it. But if I was to go down this route, I would be looking for, as I say, full English disclosure in the old-fashioned sense of the word, of all documents that undermine the case and advance the other party's case.
Your
and there would be a time limit.
Your Honor, that would benefit us, because the principle is the principle, and it's got to be happened that way, because we feel, and obviously I'm not trying to rattle my saber too early, because we feel the defendants would have to do that, and we have great concerns, because at this moment in time, disclosure has been one-sided. And when we get to the second stage, we are actually looking forward to the second stage of disclosure, because we want to see their hand. But anyway, leaving that to one side, the obligation they understand, and not to put too much of my head on the block. If this all was in the UK, I do have authority to conduct litigation, so I am aware of assisting litigants in disclosure. But here, in this particular case, the disclosure is going to be crucial on both parties, on both parts, in order to take this case forward.
Yes, well, Mr. Blackwood hasn't asked for a trial on liability of his clients in relation to misrepresentations and breach of contract by all the people he says weren't employed by him. So that would await another day. Yeah. All right. Well, I've got your submissions. Mr. Blackwood, back to you.
I'm grateful, Your Honour. I just wanted to make a couple of very brief points in response to my learned friend, and they are brief. The first being the Mashreq Bank point. I don't ask Your Honour to turn this up at the moment, but the complaint here is that what we have is an offer letter. For Your Honour's reference, it's page 586 of the bundle, which says, in order to proceed, we must provide, you must provide to us, to our satisfaction, the documents listed in Appendix A sign the enclosed loan agreement.
Yes.
And that's what we don't have, the loan agreement.
Yeah.
And in the context of an allegation that the loan agreement was repaid voluntarily, self-evidently, that is essential. It must have been received. It's not been produced. And two further very brief points only, Your Honour. The suggestion that it's incumbent on my clients to go and seek third-party disclosure orders against banks. Really, it is a suggestion that would only lead to yet further expenditure, and almost certainly substantial expenditure on the part of my clients in what's already becoming expensive litigation. And lastly, Your Honour, I just wanted to use Your Honour's own words, and this is really on my primary submission, from the transcript of the March hearing. Where Your Honour said, it seems to me self-evident that in order to make this point good, you're going to have to produce copies of the documents that set out the terms of the credit facilities, and you're also going to have to produce the document that made the demand under them.
Yes.
And Your Lordship made a very similar statement in relation to Mashreq Bank.
Yes. Well, that is what one's ordinary expectation would be.
Yeah, absolutely, and that is also the defendant's ordinary expectation, and has been, Your Honour, which is why we make our primary case. But if Your Honour is minded to do so, would this be an appropriate juncture such that we could both take instructions on these?
I think that would make sense. Let me just say this to help guide you in the process. If one looks at the matter in the round, the whole purpose of particulars is to enable the other party to understand the case that it has to meet. I don't believe in the present case there's any difficulty in the defendant understanding the case that it has to meet, though the defendant says that that case is untenable and unsupported by documents. If one looks at the response to the request for information, which extends to some 40-odd pages, with a bundle of documents attached that are indexed in 81 itemized items in 3 pages, it can't be said that there hasn't been a serious attempt to comply with the order. There are missing, as the defendant says, a range of documents that one would have expected to exist in the ordinary way in the context of dealing with banks. The position there is that Mr. Garg says, and in a witness statement says, that he has no further documents despite references in it to formal requests and the like. In circumstances where a witness is prepared to say that there are no further documents, in the context of disclosure, one would be asking for a little more information about what searches had been made and the like, and what attempts had been made to gain documents. But we haven't yet reached that stage. So far as the further information is concerned, for the moment, I have to accept that there is no question of contumelious breach here. There may be a breach because of a failure to take steps that ought to have been taken, but that I cannot tell simply from what is currently available to me. If a point is going to be made that Mr. Garg is telling lies in this witness statement, which Mr. Blackwood hasn't actually said, but leans towards, if I can put it that way, then I think that has to be a point that's tested by way of cross-examination it would be a very unusual case for a party to require a witness to attend for cross-examination in relation to a witness statement relating further and better particulars, as we used to call them, further information as they now are. So I'm not surprised that hasn't happened. Mr. Odin, who hopefully appears for the claimants, is instructed on a direct access basis, which means that he doesn't have quite the same supervisory ability over disclosure that solicitors would have, and that's somewhat unfortunate. Nonetheless, as matters currently stand, it does not look as though we're going to have solicitors available for the claimant at any immediate stage in the future, and probably not if this matter goes to trial. I am therefore looking for an economic way forward, but one which does not shut out the claimant, who on the face of it has a good claim in relation to the individuals who are said to have made representations and induced the claimant to enter into what look like circular trades, which may have had as their objective the raising of liquidity without real transactions being involved and gaining credit from the banks in that respect. In that context, the claimant would have appeared to have played a part and was due to receive a small element of remuneration for being a middleman. Where I get to on it is this: the defendant is looking to save costs, despite the fact that, in my judgment, it has so far done its best to increase costs by taking the points that it has, and is seeking to stifle this claim in the context of seeking security from a claimant who, at least on the face of it, has real problems in funding this litigation, as seen by the fact that there are no solicitors to represent them. Mr. Blackwood thinks that he has a knockout point, which relates to the closure of bank facilities, which in the defence, it's said, does not relate to these transactions at all, but is likely to have been caused by the claimant's own indigence and financial problems, regardless of these particular matters that are in dispute. It is further said that there is simply inadequate evidence being put forward as to the basis of those facilities because of the lack of disclosure in relation to the documents that you'd expect to exist in a relationship between a bank and its customers. In those circumstances, I'm going to allow the parties a period of time, and I'll ask them how long they want, for them to take instructions as to whether there is a possible route through here which enables Mr. Blackwood to take his knockout point in advance of a full trial, thus saving some element of costs, with a preliminary point about the matters set out in paragraph 43(2), so that should he succeed there, the rest of the damages, which are parasitic upon that in 43.3 to 43.8, would disappear, leaving what only appears to be a small claim under paragraph 43.1, whatever the mathematics actually results in. What I'm contemplating, and upon which I invite the parties to take instructions, is that there would be a early disclosure on that point, which would of course be again effectively one-sided, but would thereby reduce the issue of costs, and a time limit for that and the framing of a particular issue that would constitute, so far as Mr. Blackwood is concerned, a knockout blow. But if the claimant succeeds, would simply result then in the claim going forward and full disclosure and all the other elements having to be dealt with at a later stage. From Mr. Blackwood's point of view, it has the effect that he doesn't have to disclose documents that Mr. Uddin would love to see in relation to the agency and employment and holding out of the various individuals who were involved with Mr. Garg in the meetings that undoubtedly must have taken place and the representations and contract which he says exist. I hope that sort of helps by way of background so that you can take instructions in relation to these matters. How long would you need, do you think, to do that? Mr. Uddin, you've got a problem because Mr. Garg is travelling. But do you need to take much instructions? I understood what you were saying. You probably had considered you had quite a wide authority.
Your Honour, I've just had that reconfirmed to me. He's going to catch a flight and he's given me whatever I think best authority.
Well, that's a very, very sensible move on his part.
I'm grateful, Your Honour, for that. Thank you.
Yes, Mr. Blackwood, you've got
Your Honour, I don't have
a formal setup, I suspect. So you'll need to.
I do, Your Honour. I don't have quite such an ambit of discretion. So would it be convenient to adjourn for 30 minutes, as Your Honour suggested earlier?
If 30 minutes you think is adequate, that's fine.
Or perhaps could we say 10 to 10, Your Honour, London time?
Yes, all right. And what I'd like you to do, Mr. Blackwood, if you have appropriate instructions, is to seek to draft something.
Yes, we will, Your Honour.
All right.
May I just, while we're on this line, give my mobile number out to my learned friend, so it might be quicker. We're both in the UK for the discussions. May I just shout it out with your leave, Your Honour?
You may indeed.
Yes,
and what
absolutely.
I suggest, Mr. Blackwood does is to draft something and let you have it by email or whatever, and you can then discuss it. And if indeed you need a little bit more than the time that's available, you have only to tell the court. I think I will probably leave this link open, in fact, so that I shall be available, so to speak, at any point, so that you can let the court know exactly where you've got to.
Great.
And after shouting my email, my mobile out, I will then email my learner friends instructing solicitor with my email, so at least it's there, if that helps. So 0781, I do apologise, Your Honour, for talking over you.
Yeah, 0781.
21 26 561.
Thank you.
I'll email it to you, instructing solicitor as well. Your Honour, thank you for the indulgence. Thank you.
All right. Well, if you'd like to sign out then and come back in due course, I was just going
to put my camera off and mute myself rather than leave, if that helps.
Well, the only point is that I may want to talk to the associate.
Okay, I'll leave then, Your Honour.
So it'd be helpful if you would all leave so I can talk to the court associates about this. And indeed, it would help. You try to work through this if it's a possibility as to how long one would need for a preliminary issue of this kind and when it could realistically take place. I anticipate at a rough guess that we're only talking about a day or so, but you may think otherwise.
Thank you, Ron.
Thank you.
All right. So if you wouldn't all mind signing out, everybody except the court associates. Thank you. Right, is everybody back? I've just received an email with a draft, which let me look at.
Your Honour, I apologise. Your Honour was breaking up then with the transmission.
Apologies. I was just saying I've just received an email with the draft, so I'm just looking at it
Thank you.
on screen right now. And is this a draft that's agreed between the parties?
Your Honour,
Yes,
yes.
Your Honour, these 3 paragraphs are. Yeah. We've given 2 alternative dates, Your Honour, in the 3rd paragraph. I don't know if either of those are could be accommodated.
Yeah, just one point on 2. There's always a problem when one refers to standard basis because of the DIFC rules. So
right,
if we were to say full disclosure on a standard basis, in brackets, as in English law terms or something of that kind.
Of course.
Will most of this stuff be electronic?
I think so.
Well,
Mr. Adin, are you able to help me on that?
I can't, but having said that, whatever documents they are, if they're in hard copy, obviously they will be PDF'd. But I don't know at the moment. But they will be provided as. I really don't know what kind of practice and procedures the particular banks have. For example, obviously you've seen the main thrust, the verbal communication, whether we could get phone records or dialing out, etc. But I don't know at the moment.
Yeah, 10th of October is relatively soon. What my slight concern is, whilst I see the purpose of having an early hearing on the point, is that we suddenly get into an argument about whether full disclosure has been given. I can see that as a possibility, particularly given the absence of solicitors involved, notwithstanding Mr. Adin's presence on a direct access basis. I mean, in the ordinary way, you know, if we were moving to a full trial, I'd be looking for electronic documents, questionnaires and all that sort of thing, you know, that's now standard in the UK. I never want to make too much of a meal of it, but in the ordinary way, one has solicitors exchanging information before disclosure takes place so that everybody is conscious of what their obligations are. I think, Mr. Blackwood, it probably depends on you as to whether whether you're content simply to with paragraph 2 without further ado, so to speak, and no doubt you'll invite me to draw inferences if you're not happy with what's produced.
Yes, we are. Your Honour, as Your Honour suggests, we will ask the court to, or invite the court to draw adverse inferences if there is any failure to comply with paragraph 2.
Yes, well, Mr. Adin, it really will be incumbent on you to advise your client as to exactly what is required in this respect.
Your Honour,
because
yes.
Self-evident, you won't be able to supervise disclosure in the way that a solicitor would be able to.
Well, yeah, Your Honour, yes, but obviously my client's very aware the burden rests with them, and it's their case. They've brought a substantial case. They need to
yes.
Although I've approved the draft, Your Honour, I have no issues with it, but there are 2 issues that come to mind, and I wanted to ventilate that before Your Honour, if I may. Obviously, Mr. Garg will be giving evidence, and the question is whether a witness statement needs to be filed by him dealing with the disclosure, because obviously to put once you've done the disclosure, should there be a witness statement to put the disclosures into context? Because if it's going to be cross-examined, on what basis is going to be cross-examined? So that's one point, Your Honour. And in relation to the listing of the matter,
Yes.
I'm not sure whether it is possible at this stage to have a fixture date, because my diary is quite packed between now and the new year. But obviously I would want to, and having said that, looking at paragraph 3 for in-person hearings, so maybe I have to come over to Dubai, deal with them, depending on the logistics, but leaving that to one side, wherever I do it from, I would prefer to have a fixed date if it is possible, rather than. So those are the two issues that I'm sorry I didn't canvass that with my learned friend. I just approved the order, but these are things that just come to my mind now.
Well, are you suggesting another date, another one-day date? My initial thinking is that it's too quick.
Yes.
It seems to me a December date might be. I mean, actually, as it happens, I've had a few settlements, so that I'm comparatively well placed personally. The court, I don't think, will have a difficulty, but we'll check that in a moment. But Mr. Blackwood and Mr. Uddin, is there a date that works for you both in December sometime?
I would. Sorry, I'll let Mr. Blackwood finish first.
Your Honour, I could make the first 2 weeks in December.
Yeah.
I have something, unfortunately, in the third week.
Well, not unfortunately.
No. Yes, I could do the week of the 1st or the 8th.
Yes. Is anything in the week of the 8th suitable for you, Mr. Uddin?
Your Honour, I could do the 10th and the 11th. Yes, 10th and 11th, or the 12th. Other than that, then after that, I'm packed. I mean, otherwise, about 3 days before Christmas, I could come out of. So for my dates, I could do the 10th and the 11th that week, and the 12th, possibly missing a Christmas party. I don't mind, depending on where I am, or alternatively, I could do the 23rd or the 24th.
Yeah, well, I don't suppose the 24th is going to be very popular as an idea.
I don't mind spending Christmas in Dubai, but.
Well,
I think I'd be paying alimony if the 24th was fixed upon.
Yes. Yes, well, I don't think we'll go for the 24th of December, certainly. What we're envisaging here is an in-person trial.
I think we do have to have that, Your Honour, because I have to put questions fairly directly to the witness by reason of the questions which I will obviously be putting.
Yes, well, I think that's right. It's a bit unfortunate because on that basis it means everybody's got to go to Dubai just for the one day, but there it is. But I agree. I personally always find cross-examination of witnesses online to be not as satisfactory, because you don't get the immediate response and so on that is required.
Your Honour, just to interpose in relation to fixing,
yes,
if it's going to be fixed on that week, the second week, I would prefer the 11th or the 12th. The reason is, on the 9th, I have a hearing in the UK, so I would have to catch my flight either that Tuesday evening, which I can do possibly, but I'd prefer to have that 1 day break before starting the trial. So 11th or the 12th, subject to my learned friend's availability, would suit me. 11th or the 12th.
Yeah.
Yes, that would work for me, Your Honour.
Well, I think the 11th looks the best date on that basis, because depending on whether people want to fly overnight and that sort of thing, I personally usually prefer to get the early morning flight back, which will be on a Friday morning. So if we say Thursday, December the 11th, subject to the court having availability to to cater for the trial. I don't think it's likely to be a problem. Alia, can you check the 11th of December to make sure that that's a date that works?
Yes, Your Honor, I'm checking that right now.
Thank you very much. I mean, if necessary, we can always use the other building, but
one possibility, Your Honour, my learned friend suggested that we could also potentially, if it's more convenient, I don't know about the witness, have the hearing in London, and to my learned friend.
I don't think that works from a constitutional point of view.
Yeah, that's what I was concerned about. Yes,
there's an issue about that. There was originally an issue about even doing video hearings from London,
yes,
which is
in fact,
why we have the form of words at the beginning that this hearing is taking place in the DIFC.
Yes, I've had a firm refrain. I think the
answer
as well.
is no.
It is.
I mean,
yes, it is. Those are my instructions. Yeah.
Alternatively, Your Honour, one other option may be a hybrid, whereby witness has to attend the court, and advocates or not everybody. It's just a matter I put there if it is possible, just in case there are any inconveniences. But the main thing is to have the witness in court rather than have everybody else, I suspect.
Well, on a case like this, I think, say, if Mr. Blackwood wants to cross-examine in person, that I fully understand, and it seems to me that that's more beneficial from the court's point of view, where you get the immediacy in cross-examination that you don't really get online. From your perspective, Mr. Ardin, it may be much less important if you want to join by video to make submissions and so on. Re-examination. If we have a witness statement in advance, then there won't be examination in chief, and it would only be re-examination that you'd be required to do. But you can cross that bridge when the time comes, I guess, if you suddenly find you've got a problem and can't get out to Dubai for the Thursday.
Yeah, my only reason I start the following Monday, I start a very heavy trial for 5 days. So if I can do hybrid, but I would prefer to be over there with my client, especially a client who doesn't have solicitors. But I will do it just in case there's an issue with my other trial.
Yeah, all right. Well, subject to the court saying the 11th of December is all right, let's go for that.
Yes, Your Honor. I confirm that the courtroom does appear to be available. However, I'm going to just confirm with a further check, and I can communicate that to the parties and yourself very shortly.
Thank you. If we go for the 11th of December, then do we want to retain the date in paragraph 2? Or is it more sensible to give a little bit more time? And what date would you produce a witness statement, Mr. Ardin?
So, Your Honour, if I could, so if we move the 10th, just to be on the safe side, to the 17th, because I appreciate I've got wide authority from my client, knowing about the case. As far as we're concerned, we've disclosed everything we've got and everything that we should have. So if I just do on the safe side, if I say the that date to change to the 17th, just an extra 7 days. And regarding the witness statement, once disclosure has been done, then we'd need to have witness statements. So if we could go to the witness statement, say the 7th of November, then that gives enough time, subject to Your Honour's approval and my learned friend's consideration.
That's on that basis, you've got a month before the hearing after getting the witness statement and the full disclosure. Are you content with that, Mr. Blackwood?
Yes, Your Honour. I will just check with those instructing me, but I can see no problem with the 17th and the 7th on that timetable, heading for a hearing on the 11th.
And we'd have skeletons, which could be, I think, pretty short. I can't see the need for anything very extensive. what sort of length skeleton? I propose to set a page limit on skeletons so they don't get out of hand, because my perception is that things have got out of hand so far. How many pages do you think you're going to need, Mr. Blackwood? It's probably you who are likely to be saying more.
Yes, Your Honour, 10 at the maximum,
All right.
and that's generous.
Yes, 10-page skeleton, 48 hours beforehand, something like that.
48 hours. Yes, Your Honour.
Thank you. All right. Well, I think that does it then. So the preliminary issue is as framed in paragraph 1 by agreement. I'm just going to look at that more closely. Yes. I think I would rather paragraph 2 were framed. Let's just look at the way it's often put. I think I prefer it, say, to provide full disclosure on a standard basis of all relevant documents which either support the claimant's case or undermine it, or support the case of the defendant. So it's absolutely clear what it is that has to be done. And it might be all material documents, all relevant and material documents. We obviously don't need all, well, there won't be lots of other stuff, I'm sure, in this case.
And material.
And then the dates are then as we've given them. So
Yes,
that will be the 17th of October. A new paragraph 3, the claimant to produce a witness statement in support of its disclosure obligations, stating what steps have been taken to ascertain and disclose the documents that have been sought. And then by 7th November, and then the 10-page skeleton, maximum 10-page skeletons, 48 hours in advance, hearing to take place on 11th December in person in DISC. Mr. Blackwood, because you have more facilities, are you happy to draw up that order and submit it to the court?
Absolutely, Your Honour, we will do in short order.
Very good.
There are two ancillary matters. Sorry, Your
yes,
Honour.
there are.
The first is costs, and this hopefully will be uncontentious. I was going to propose costs reserved to the hearing of 11th December 2025.
Well, it's either costs reserved or costs in the preliminary issue or something of that kind.
Costs, or costs in the costs in the preliminary issue. Yeah, I'll be happy with either of those.
Mr. Ardin, do you have any?
No, Your Honour, I have no objection either way.
Well, I think costs in the preliminary issue makes sense.
And then the separate issue of security for costs,
yes,
Your Honour, for this hearing, and the question of stifling. Obviously, the quantum.
Can I just tell you what my tentative position is on that, so you can address it. My tentative position is that you are trying to stifle this claim, but there is no adequate evidence that it has necessarily that effect.
Absolutely, Your Honour, and that was really the point I was going to focus on. In particular, the evidence in the witness statement of Mr. Garg. It's at page 2701 of the bundle. I won't try and give Your Honour tab numbers. I hope Your Honour has it. It's the witness statement of 2nd September 2025.
Yes, I have. Yeah.
Sorry, Your Honour, sorry to interrupt. I was just going to make a very short preliminary point. I'm wondering, now that we have a preliminary hearing listed, whether this application could wait till then.
Unfortunately, it can't, because it is for the purpose of the preliminary issue. Obviously, yes. The quantum is not going to be in the same sort of magnitude.
Well, tell me what you'd be asking for.
Something of the order of $200,000, or alternatively, Your Honour, we could put in a schedule of costs if Your Honour wanted something more detailed. Obviously, we haven't done so, which Your Honour could perhaps determine on paper, because the schedules we have produced are proceed on a different basis. Of course, the security for costs.
Again, expressing a tentative view, which again, it's open to both parties to address. It seems to me that Mr. Garg ought to be able to lay his hands on some amount of money, even though he can't afford representation by solicitors. And my inclination would be to order a small sum so that he puts his money where his mouth is, if I can use that colloquial expression.
I'm grateful, Your Honour. I was going to address Your Honour very briefly, but I will keep it brief, just on what effect any attempts at stifling, which of course we would resist that categorisation. But one can see, Your Honour, from subparagraph 2D, page 2703 of the bundle.
Yeah.
That the only change in circumstance since March is said to be the prospect of external litigation funding from Omni Bridgeway has receded. That's said to be in paragraph 2 due to the defendant's delayed filing of its defence, the funder's requirement to add parties, and the claimant's inability to object further funds. So it really is very thin gruel on which to hang a stifling claim. As Your Honour will be aware, the authorities say one needs to evidence, and that's the party on the receiving end of this type of order, that it is impossible to obtain funds from any source, directors, shareholders, or other interested parties, or indeed here other funders. Just noting in passing that Mr. Garg and another director were guarantors of some of these loans and provided statements of net assets to the various banks. I can give Your Honour a reference to those, if that would help.
Yes.
Taking the Bank of India as an example, page 569 of the bundle. One can see, for example, at the time that this loan was entered into, Roman numeral 5, securities and conditions precedent. One has a first charge in equitable mortgage over a property in Delhi, but personal guarantee.
Sorry, Mr. Blackwood, can you give me the page again?
Of course, it's 569, I think.
Thank you.
In the updated numbering.
Yeah.
Bank of India loan. I was just reading from Securities and Conditions Precedent. C, a first charge, but more particularly D and E, personal guarantees of Mr. Garg and a Mrs. Kangan Dewan, said incorrectly, I'm sure, and an undated check drawn on another bank for the amount of $4 million. Of course, checks take on particular significance in the UAE.
Yeah.
And para 12 of the conditions, one had a fresh net worth statement from the guarantors, latest net worth certificate of Mrs. Dewan to be submitted immediately. None of this has been disclosed. We have seen none of it. So that there really is no basis for thinking that the claimants cannot lay their hands on that sort of sum, and really ought to be required to put their money where their mouth is. We would suggest a security in the order of $200,000, or alternatively, if Your Honour wanted something more detailed, what we would suggest is putting in a detailed summary assessment, 3 or 4 pages, to show what the figures are, and invite Your Honour to determine that issue of quantum on paper.
Yes, understood. Mr. Adin?
Well, Your Honour, first of all, the principle of the amount, the principle of the security of cost. I hear Your Honour's sentiments. It's an attempt to stifle, but notwithstanding that indication, Your Honour would have seen the statement from Mr. Garg at page 2701 of the PDF. They just don't have the resources. The company, there has to be a distinction between the company and Mr. Garg. But in any event, if that was the case, if there is an element, if Mr. Garg were to say, I offer security, then that is one way of defeating a security of cost application. There is case law to that effect, but I'm not going to go down that route because we haven't dealt with the issue. But I think what my learned friend, if Your Honour is not with me and I'm not going to be able to persuade Your Honour that in this particular instance, security of cost should not be ordered. And even when one takes my learned friend's authorities, bundle of authorities, for which I'm grateful for, there is this issue of stifling a case. And in this particular case, in my response submission, from what Your Honour has heard and seen, the company, the claimants appear to be impecunious, and therefore an order for security of cost would stifle the claim. And Your Honour has said earlier on in this hearing that it appears to be a good claim. Quoting your
against somebody.
Sorry?
Against somebody.
Someone.
Yes, yeah, against somebody. but the point of the matter is this, Your Honour. It's a claim, and it is a good claim, and it would have the effect of stifling the claim, unless Your Honour wants me to take to the particular case law that my learned friend, but it is clear there, and I do agree with that case law. I'm just trying to get my hands on it to the particular section, but in any event, I think I've got it here. So my primary submission to Your Honour is to persuade Your Honour not to order a security of cost because of you've seen the witness statement from Mr. Garg. You know the circumstances that I appear on. There's been substantial submissions already made in that regard. I think my predecessor dealt with that aspect as well, and I don't want to repeat that. But if I just have a moment to get to particular, I'm just going to turn my back to my setting.
Well, I think it's the Al-Kharafi case.
That's right, Your Honour. That's right. Absolutely. Yeah, and very helpfully included by my learned friend. So, and also in my skeleton, I've referred to that as well. So for all those reasons, my primary submission is that it would stifle the claim.
Yeah,
and there is an air of that. My secondary point, well,
yeah.
and we've got a preliminary issue coming up anyway. But if your honour is not with me on that, if I could, I think my learner friend's suggestion is to submit a summary so your honour could deal with the matter on papers as to quantum. I mean, £200,000, if I could just say, it's just eye-watering amounts. $200, it's eye-watering amounts on a case of this nature, especially a preliminary hearing. I appreciate the ultimate value of the claim is high. I appreciate the defendants have the benefit of a King's Counsel as well as junior counsel, but a person may want to attend court in a Ferrari, but that doesn't mean to say they'll get the cost of a Ferrari. They may get the cost of a Uber to travel to court. But the point of the matter is, it's the court, Your Honour, has wide discretion on cost, but everything has to be dealt with on the overriding principles of doing justice.
Yes, but what you say would be a reasonable figure for what has to be done now in examining any further disclosure that you give, your witness statement, preparation for a one-day hearing and the one-day hearing itself?
In dollar terms, Your Honour, I appreciate there are two counsel in this case. Taking a broad brush approach on a preliminary issue of this nature, I'm sorry if I mean, I just did some rough calculations. Yeah, I can't see. I would suggest about $25,000 US.
Well, that would be putting Mr. Blackwood at. He would be very cheap at the price, I think. Whether or not Mr. Cherryman is involved.
But I did preface it with the fact that if somebody wants to attend court with a Ferrari, then.
Well, I understand that, and maybe they have to do without the. No, I shan't adopt the analogy. You may have a Ferrari, but you don't bring the other car with you. Yes. I don't think that's a realistic figure. To be frank, Mr. Uddin, I'll ask Mr. Blackwood what he thinks of the figure would be on that sort of basis. So I'm not looking at past expenditure at all, Mr. Blackwood. I'm just looking at what the cost is going to be of securing you for dealing with this preliminary issue on the basis of the order I've just made.
Your Honour, what I would say is that the term sheet, and I appreciate this is for all of the litigation, which Mr. Garg signed, was for 1.8 million.
No, I've got that.
I've taken instructions, and those instructing me are of the view that a reasonable figure for the entire exercise, of course, including myself and themselves, looking at disclosure and the like, would be $200,000. $25,000 is not realistic. It would only cover a very inevitably small proportion of the costs which we will have to incur. We have to get to, or I'll have to get to Dubai, and those instructing me are going to have to look at all the documents, and you know, a reasonable amount of preparation for a cross-examination of this type is going to be required, because I'm going to be putting serious points to the witness, and it's a very serious case for my clients, because at the end of the day they're an important and well-known commodity trading firm in Africa, and the allegations are serious ones.
Yep.
Well, sorry, I do apologize. Just on the Omni Bridgeway, I purposely didn't deal with it. I didn't think it was relevant, but that cost budgeting, Your Honour, is not for the cost. That there are built-in about paying an insurance premium for adverse cost orders, their own budgets, but this is not for the claim. It's the claim. Sorry, the defendant's cost. There are other issues, but I didn't purposely deal with that issue in that regard. So I have seen a witness statement from my learned friends instructing solicitors regarding that, but it's wrong to assume it's 1.8 million. That wasn't the case. That was a total funding, overall budget for a lot of other things.
Yes, all right. Well, my conclusion is this. As I say, I do think the defendants are doing their utmost to stifle this claim. I don't think there is adequate evidence that the claim is stifled, because there is no evidence from the claimant of the kind that's required to support that proposition. That would need evidence that funding was unavailable to the claimant from directors, shareholders, or any other source to enable the claim to be pursued. Having said that, it does not seem to me appropriate, particularly as I take the view that a lot of expenditure incurred thus far has been inappropriate. It doesn't seem to me that the security for costs should cover anything other than what is yet to come in relation to the preliminary issue. And obviously following that, matters, if the case still stands, matters would have to be explored again. Looking at that question, there is a limited period of time involved. There are limited issues to be dealt with. And I can't see that anything more than 100,000 is necessary for security for costs. That is a broad brush approach, but that seems to me to be about the right sort of figure. That would be recoverable in any assessment by the registrar. So it'll be $100,000, and the question will be the date by which it's to be obtained, and it will be $100,000 in a form reasonably satisfactory to the defendants. Could be payment into court or other form reasonably satisfactory to the defendants. What sort of date, Mr. Ardin?
Can I ask for 28 days? Obviously, it's a large amount of money, but we'll...
Yes, well, I'm just looking at the date when the burden is on you in terms of disclosure and witness statements. Yes. 28 days will take us to the end of October sometime.
Yes, Your Honour.
Yeah, that seems to be sensible, Mr. Blackwood, unless you have any problems with that.
We don't, Your Honour. What we would ask for, if it's 28 days, it is at liberty to apply on paper for a strikeout or stay in the event that the security is not provided. In other words, we get to the end of October, we're incurring money, and rather than being, in order to ensure, as Your Honour put it, that the claimant's putting his money where his mouth is.
Well, I think there's liberty to apply regardless, but if you want liberty to apply, you can have it.
Thank you. On paper, ideally, Your Honour, so we don't.
Yeah,
need
yes, I
hearing.
think. Yes.
Thank
I
you.
think paper makes sense. All right. Does that cover the ground then?
Yes, Your Honour. I don't think there's anything further from us.
Mr. Ardin?
Yes, Your Honour. Nothing further. I think it goes without saying. Everything else is postponed. I.e., the CMC is postponed until after the.
Yeah, we'll cross those bridges when we get there.
Thank you.
Very good. Well, if Mr. Blackwood wouldn't mind and his solicitors producing a draft order and sending it to the registry, they will then forward it to me. Send it to Mr. Ardin first, obviously, and then make sure it's in agreed form. And I suppose I shall look forward to seeing you on the 11th of December.
Absolutely. At least it won't be too hot, Your Honour, at that time of year.
No, I can think of worse places to be in December. This is true.
Absolutely.
All right. Many thanks indeed.
Thank you, Your Honour. Thank you for your.
Would you all sign out once again and just leave me to have a word with the associate? Thank you.
Of course.
Thank you, Your Honour. Thank you. Good day.